shown a bit of grace in this whole picture. She grew up in Wisconsin with a fabulous family who encouraged education and a belief that you could do anything you put your mind to. Stephanie enjoyed athletics and academia in high school, during college at Smith in Northampton, Mass, and then at the University of Denver for law school. Ski racing and skiing in general has always been a big part of Stephanie's life and has guided most decisions in life. There were dreams of negotiating sponsor contracts for World Cup athletes or working in a house for a ski area, but the arrival of her 3 children quickly became a priority. During preschool, during the fire drill conversations, the question was posed by a 4-year-old, what do we do if we don't wake up? And thus the journey into estate planning began. Stephanie started a solo practice to balance work and life needs and has grown a rich, thriving boutique practice while being a single mom to amazing young adults. She's here today to speak to us. Welcome, Stephanie.
Hi, thanks very much. I'm so excited to be here. So I came into estate planning with one of my children saying, well, Mom, what happens to us if you don't wake up? And realizing that kids want to have a plan and boundaries. And so creating a plan where they would walk to the babysitter's house, like on the block. And then if they weren't there, like winding around to our friend Sally's house, where they had friends Jack and Riley, and that potentially they might have to have a sleepover with Jack and Riley until like either their dad could come or like my brother would get here. And I saw this glint in their eyes thinking like we could have a sleepover. And I thought maybe they would kill me because they didn't really get sleepovers very often. So I called Sally. I'm like, we need to have a sleepover so my kids don't decide I should be dead, so they can just have one. So, and my aunt, Nancy, who had just been redoing their plan, had a friend in California that had done it sort of, you know, in between raising kids and had grown her practice. And she said, oh, this sounds like something that you might really like. And again, I was like, death is sort of not what I thought I would do in my life. But she had never steered me wrong. So I started taking some more continuing legal education classes around estate planning and found it to be a really incredible way to practice law because it's not adversarial. It's really just helping families who love their families. And so that felt really good. And I intuitively started working with like, well, how do these documents get used and how do you let people know that they exist, and started talking to hospice people and emergency room doctors and incorporating you know, more guidance in areas that weren't necessarily legal. But what I feel like is if you can unite a family in the care ahead of time, then they are less likely to, you know, protest a will or get as grumpy if things don't go as exactly how they were hoping, like financially, or that they were supposed to be, you know, the personal representative, or they should have taken care of things. And so, you know, promoting conversation and then that care in the documents, for me feels like really holistic and a really great plan. And then I had a client say, oh, like I found this class and it sounds exactly what you've done for us. And it's called an end-of-life doula. And so I became certified as a doula too, and then was able to learn more actually about the dying process, because I find that it's very interesting that as an attorney, a lot of people, I'm the first person someone talks to about dying, because like you're supposed to adult and get this plan. And, you know, stuff that they don't teach us in law school that helps really, you know, complement the plan. And so for me, it's been going really, really great. And I love what I do and how I do it. So that's pretty cool. So as this is sort of focused on people as caregivers, I wanted to just say that palliative care is not giving up or thinking that you're going to die. It's really about comfort care, and that you need to have, like, as a caregiver, you can't do it all by yourself. And so make sure that you there's places where you can get respite care or people to come in and help you. And like, you have to put your own oxygen mask on first before you help others. So like, just, keeping true to yourself and keeping yourself healthy will make you a better care provider. So in the legal realm, like, what can help you as a caregiver when you're needing to make decisions? I think the first most obvious document would be a medical power of attorney. And there are forms online. I think Colorado has one. And what I want to recommend is that, like, if you're the caregiver and you're the primary, you want to have, again, like this team idea where one person acts at a time, because you do not want to try to have multiple people coming to consensus if it's an emergent situation. But you want to have people who can back you up as the primary caregiver. So I like to have usually like the at bat, on deck, and in the hole, but they can add as sort of many people as they want. And then in that sort of team building, like, are there other people that should clear HIPAA? And so there's also like a HIPAA clearance form that you can create, so that you may be making the decisions, but a sister out of state may want to ask the doctor a question. And it's really important to have that happen, like, legally. Especially during COVID, when it's harder to get into the hospital to ask questions. I had a family that their dad was in a facility in like Virginia, and they couldn't get in, and there was one of the siblings that was named as a agent, but the other two, like, that power of attorney did not grant HIPAA clearance to the backups, and so the nurses wouldn't even talk to them, and they were trying to make decisions. And the one person who was named was really, really busy and didn't really have a lot of time to, like, during the workday or during even evenings, get on the phone and try to track down nurses or doctors. And so making sure that everyone can get the information and is a really important thing, so that the communication, like, outside the hospital can be amongst the people who care about the person. In the ones I create, I do encourage the engagement of palliative care as quickly as possible, because it doesn't mean you're getting ready to die. It just means that there's going to be a medical professional that can advise you as a caregiver, which may prevent getting to the hospital because you don't know what else to do. And then the person, had they stayed at home, could have maybe died in the next 48 or 72 hours, but now they're hooked up to bells and whistles and artificial heroic measures and things. And so that's when it's really important to have the advanced medical directive or a living will. And that document it says, two physicians have to agree that whatever is being done is just prolonging the inevitable. And then the person the patient or your loved one would initial, like, their choices in what they wanted to have happen. My work as a doula, as well as my education as an attorney, sort of meld here, where initially I was thinking, like, oh, like, you want to give the decision maker flexibility and keep people maintained for a while, so that people could get in to visit or things like that. And then when I did my doula training and was informed that hospice really doesn't want to know like how many days, because, like, when do they start that countdown? They want to know maintained or not maintained. And in order for two physicians to actually monitor the person for enough time to make a diagnosis and come to consensus is more likely enough time for a family to get in. So my counsel when I am creating that document for my clients is to have them remove or withdraw like the heroic measures as soon as that determination is made. You know, and there's a lot of reasons people do that. You know, some are worried about how expensive it's going to be. Some of it's going to, people worry about like, you know, the emotional, just like people waiting for, you know, for them to die. And generally most people, when they don't have a quality of life, don't want to have just be laying there on being maintained without being able to, you know, eat chocolate or go skiing. So that's my sort of my, you know, there's a Tual Gawande has a book called Being Mortal, and it, you know, talks about your standard of life and how it changes over time. And I think my my baseline is as long as I can enjoy chocolate, like, you know, there I will have quality of life. So so that's an important
Dark chocolate.
Yeah, maybe with some caramel and sea salt too. So another important sort of piece of what will make it easier for caregivers, where either, you know, they're caregiving and there's peace of mind for the patient, my client, is knowing like how their assets are going to be distributed and who's going to take care of distributing those. And so there are some different ways you can do that. There's a, you know, a will. Probate in Colorado is not terrifying. It's actually quite simple. If we were living in California, I would not be writing wills. I would say the trust I'm going to create for you will be, you know, this is what we're going to do. But you can use a trust in Colorado as well. Depending on, you know, there's a lot of different factors on which dispositive document you use. If there's property in another state, I highly recommend a trust so that you don't have to have a probate somewhere else where it may be more complicated and it would cost more time and money there, where you can just do a deed and move all the property into a Colorado entity, or a Colorado trust. And then a lot of assets pass outside those documents too. So if you have IRAs, investment accounts, bank accounts, most financial institutions want you to create a beneficiary designation on those accounts. And those override the estate plan. So it's a contract you have with that financial institution. And it says, this account goes to these people or this person or this charity. And they're going to do that, even if the will said, all my assets go into this document and here's where it goes. So if there's conflicts, it's going to prevail that the beneficiary designation overrides anything else. And so it's really important, sort of as a caregiver, to help the person check that, because sometimes that hasn't been done for a really long time. Sometimes it may be like, depending on, you know, there's as many unique situations as there are people. So like sometimes it still lists, you know, like an ex-spouse. Sometimes it could list a spouse who's predeceased the person. Maybe it's a sister they no longer talk to, or if there's, you know, kids, maybe there's addiction issues, you know, so, and having something passed directly to that child could be really detrimental to the child. So it's important to look at all, like life insurance, beneficiary designations on bank, all the different accounts. In the Secure Act of 2019 changed how IRAs and 401ks get distributed. If the beneficiary is a spouse, it can go into an inherited IRA and it would key off that person's age, and they could take the required minimum distributions, through their lifetime. If it would go to a child, or it's fairly complicated. If it goes to a child, that child has to take the entire amount out in a 10-year period. If it would go to a sister who's within, I think, 7 years of the holder of the account, or they could then take it out with the required minimum distributions. It's an age factor. The government decided they were not receiving enough assets or taxes on these assets because they kept just rolling over. So they've created a situation where the assets have to come out in 10 years. So that changes a lot of how people used to save and used to think, here's how my assets are going to get distributed. It'll be over time. So it's just something to contemplate, that your child could have it all at once if they wanted to, and and when it comes out, all the tax gets paid. They could take it out in equal 10-year increments, or they could wait till the last year and take everything out in the 10th year. So you don't get to control that in any way as the owner of that account. Like, the kids get to do that. So again, just good conversations to have, and awareness around sort of that distribution.
There's reason to go back if documents were done before 2019.
Yeah.
Okay.
I mean, and right now it should, like, if you haven't looked at your beneficiary designations, everything should get looked at, but it's especially important in those kind of retirement assets that went in tax free, or without, that it's gonna be a bigger thing, and it may be time to talk to an accountant about that, or a tax professional too. So I got an A in tax, but that was like in 1994, and a lot has changed. So I have to also talk to tax professionals for myself and advise for other people, because it's always changing. Another way to dispose of property is and real property, so houses or farms, condos, is with a beneficiary deed. So that means that after a 4-month period, the house would be free and clear, and it wouldn't have to go through a probate. And so the piece there is Medicare, Medicaid is a super creditor, so it doesn't pass automatically upon the filing of a death certificate, because you have to wait to see if there's going to be a creditor claim against the house for any Medicaid. And so but it does, once that 4-month period is cleared, then it does transfer without having a probate. So the other,
you said Medicaid is a super
creditor. So the IRS and Medicaid, they have the highest priority in recovering debt or assets.
Okay. And they're able to do that within a 4-month period.
Generally, a creditor period in a probate is 4 months, so that they are supposed to come forward within a 4-month period, or the claim is barred. And that it's 4 months when you do part of the probate process is publishing notice to creditors in a local newspaper the ad runs 3 weeks in a row. And then as part of a probate means that you are administering a will with the court's authority. And so you file the will and a petition for probate, and asking for an appointment to be the personal representative. And that then gives you the ability to act on the behalf of the estate or the person once they've passed. So powers of attorney, medically and financially, are exist while the person is alive. The minute the person passes, that power is canceled. So it makes more sense medically because there's no more medical decisions to make. But financially, when you have a financial power of attorney, and you were able to access bank accounts and write checks and pay the bills, that goes away, and then that access is reinstated through the court process with the powers, with the personal representative, and the court issues a document called, if the person left a will, it's called letters of testamentary, and if the person did not leave a will, it's called letters of administration. The great thing about having, like the powers of attorney in place and a will in place is that the people that you have asked, that you feel comfortable and trust, are being asked to do those roles. And it's always an appointment or a nomination, so that if something is going on in the life of the person that you have asked, like they're battling a disease, or they just had their mom pass, or whatever that is, they can decline the nomination. And that's why it's really great to have a team, so that someone else is in place to take over. And so and it's also really good to ask the people if they're willing to be on your team, so that it's not a surprise. It makes for really great TV drama, but it's really not a great situation when, like, you give, custody of a child, or ask someone to, like, dig into, years of really badly managed finances, and they don't even know where to begin. So being really as organized as you can, and as simplifying, so that what you want to do is make it as easy as possible for the people that are either managing it and paying your bills while you're alive, or wrapping things up once you've passed. So I like to call it, and I think the handouts have this somewhere, it's like leaving a map, not a mess. So some of it's really practical, like passwords are a really big deal. Like, how do you get into the accounts? And this is more of a do as I say, not as I do, because I have a spiral notebook that has all my passwords in it. And I had children so that they would remember my passwords. So I don't sometimes keep as good a track as I should. So I just know that they know them better than I do this, so they should be fine. It's my brother who's my PR that's going to really, be in a world of hurt, because he'll be like, what am I supposed to do? And my kids will be like, Uncle David, here's where she go call Craig at the bank. And I do have a list of, like, where my my bank accounts are, and who my financial planner is, and things like that. And that's an important piece too, is so that your people know who to call, and that your advisor or your accountant should know who's going to be calling if they need questions, so that even if there's not a formal need or a legal need for it, like, if it can be a soft intro, and not like someone coming in demanding, I need to do like, we need this and this and this because this is what's going on. Like, if they've already had a conversation, or the person knows that Emma is going to be calling you someday, then it's going to go smoother. And that's what we want to give, as much smoothness to the people that we love, because they're going to be having emotional grief and trauma, no matter, even if you're going to survive this accident, and that's why the powers of attorney are being used, it's still a lot of emotion. And so the better we can prepare people and ourselves for it, the better off we're, the easier it will be to recover. And again, I'm sure there's a lot of people who else talk about the grief thing, and it's a real thing, and your brain stops. And so if you can leave them really great, a map, and I use purple folders so that you can say, just find my purple folder, because it's way better than manila, and it stands out. Then at least they, maybe it's in the back of their mind, like, oh, wait, oh yeah, she said a purple folder or something. here's where it is. And then at least you could, write letters or, have your documents and have your wishes in one place. I've had people, like, literally the dad has labeled the file, dad is dead file, and all of his stuff was in there. And I really wish I could have met him, because he was super organized and had that. And then he did a great job of guiding his kids, so they were all united in the in all of it. So and then I guess I am jumping around a little bit, so I apologize, but I want to step back into the probate process just for a minute. So we talked about notice to creditors, and that the neat thing, and neat is because I'm a bit of an estate planning geek, like, oh, this is so cool, and neat is different, like, in, I'm not in a candy shop, like, it's not cool or neat, but it's really helpful, I guess, should be the piece, is that if the creditor doesn't come forward in that 4-month period, their claim is barred. And so you're free to distribute and not worry about, like, someone coming back in a year or 2 years and saying, oh, so-and-so owed me $50,000. Like, oh, too bad. Like, you didn't come forward in the appropriate amount of time. And so it just doesn't exist anymore. And so that piece of probate can give peace of mind to the personal representative, that they know they're not going to be tracked down later and, like, asked for money. And then there's pieces that you have to do around inventory, and any beneficiary gets a copy of that. And then you just have to keep, and everyone should keep, if they're caregiving and spending someone else's money, keep really meticulous records of what was spent and what it was for, so that, heirs or beneficiaries can't come forward and then question you, like, well, where did the money go? Or why did you spend this? Or how did you make these decisions? And so having the conversation about the end of life plan, about whether it's hospice at home, or do you want to have caregivers, and, like, the financial sort of, there's cheaper ways to do it and there's expensive ways to do it. And it's your money, or it's the person's money, and they should get to do whatever they want. And yes, we all want to, like, leave a legacy or whatever, but we also earned it, and we taught a lot of people how to eat with forks. And so, like, what we should do is take care of ourselves now. And that's what most of our family wants for us too. We want to be safe, clean, and, and comfortable. And so I think making sure that happens through all the different documents is an important, like, don't not consider, make sure that the person gets to consider themselves in the conversation. And so when people get to have their inheritance or their gift, it's in Colorado, inheritance is not taxed, so it doesn't have to be reported, like in your taxes. Some other states do tax inheritance, so that's just something to consider, as you're giving things away. But just it's a nice piece. Colorado is a good place to live and to die. And then sort of when all of those things are given out, I recommend that the personal representative does a receipt and release, so that the people sign, like, here's what I got, and I release the estate now from anything else, so that, again, it's protecting sort of the personal personal representative, which is, in some ways still the caregiver of the estate, from people saying, like, I was supposed to get, or I never got the whatever. No, here it is, you've signed off. And so again, it's an important sort of tool, and all of that is filed with the court, so that they can't come back to the court later either and say, the personal representative didn't give me this or that.
And it's a great time for us to entertain a question here.
Okay.
Hey, Stephanie. I have a question. Thanks for doing this today. I know you've come up to talk to Ward before, so I really appreciate this. You were talking about in Colorado, inheritance isn't taxed. If my clients have out-of-state children, will they be taxed in their state?
Potentially.
Okay.
Yeah, it would depend on their on what that state's law is.
Okay.
And just like the IRA, like the retirement account, that distribution is taxed, even though it's inherited, because it went in without tax. So it's going to come back to the people with tax. So
Makes sense.
Yeah.
Okay. Thank you.
Yep. So sometimes people want to avoid a probate. And a reason that can be important to have that process, so that not like everyone's like, oh, I want to do the beneficiary deed and the beneficiary designations, and everything's going to pay out, to my children or to my beneficiaries, and I can avoid that probate. But then if there's bills, or there's, you owe money, a creditor can actually open the probate, and then they can claw money out of the beneficiaries and bring it back into the estate to pay for the debt. And so it is a little bit easier to have some structure around that. And I always feel like it's better to get less than have to give something back, and have it settled, versus having to sort of wait. And so if there isn't a probate, a creditor can open one, if the debt is significant enough. And then you want to be able to pay, so maybe even like an insurance policy, the beneficiary designation is your estate, so that there's money that can come in to pay for last expenses of an illness or the funeral, or any sort of fees, that need to have happen, which can be varied and multiple,
Right.
depending on what's going on in your life.
And so before you go further, Linda has a question.
Okay.
Yes, thanks. Quick question. If you have power of attorney established, but you've not done the personal representative because the attorney didn't tell you that the power of attorney would end at the time of death, is that a separate document that you can just go back, or is that to declare the personal representative beyond the power of attorney at the time of death?
Yeah, a will is the document that nominates a personal representative.
Okay.
And if the person doesn't have like a will, their estate still gets probated. It's just called intestate. And you can still be named that person, but you don't if it's not in a will, you don't have priority. And so if you were going to be the person doing it, potentially you would have to open formally, or have a non-appearance hearing, so that if there's other people that feel like they should get to do it, that they can chime in. And I saw a question come up that says, is an executor the same as a personal representative? And that is true. They are just different words for the same role. In Colorado, we use personal representative more. Other states use executor more. So just really good to have, some liquidity in the estates to pay the bills. Other important documents to consider is a disposition of remains, and probably the natural funeral took that, or addressed that. But legally, my understanding is if you want to be cremated, and your sisters think you should be buried, it's a nice thing to have that in writing, so that your wishes are followed through and that the funeral home can rely on your, like legally, it's called disposition of remains. Like that is a legal document. And as a signed writing, then they can rely on that and not have to deal with the conflicting input from family. If you want to be a whole body, like a cadaver for a med school, or do a whole body donation, there's a form for that as well that you need to fill out. As a medical power of attorney document, you can, or the medical agent under that medical power of attorney document, you can facilitate the donation of anatomical gifts as far as like bones, cornea, tissue, organs, but only the client, the human, can donate their whole body. So if that's something that's important, you want to have them sign that themselves. And then there's, medical aid in dying is in Colorado, and it's being used. And there's a lot of hoops to jump through in that process. But, so there will be, letters and finding the right physician and the request and, Zoom calls now, and potentially even visits with sort of the doctors who would prescribe the prescription, and then pretty stringent requirements on the procuring of the prescription and how the patient, the patient has to be able to take the prescription on their own. Someone can mix it, but they have to be able to ingest it on their own. And so, those are just different sort of things legally to be really careful with. But I think it's a really nice option. And I guess more as the doula part of me than the estate planning. Although I will tell, like, a nice thing is that it does not negate a life insurance policy. So if someone chooses to do medical aid in dying, their life insurance policies still pay out. So
that makes it very complicated if a caregiver is working with somebody who has dementia, presumably.
Oh, you have to have capacity to do medical aid in dying, and you have to have capacity to get a lot of these documents done. The level of capacity for medical aid in dying is more stringent than like the testamentary capacity. So like, if on a good day, you can tell me where you want your stuff to go, I can write the documents. If you can, tell me, and sort of independently. And that's the other piece, is that generally I try to have my client meetings with just the client, because of the undue influence sort of situation where there could be pressure to do it one way or another. And if I'm going to have a conversation with one sibling involved, I want all the siblings to sign off on it. And I either do a Zoom call or a regular call, or, call siblings, or children, independently, and say, hey, this is what I'm doing, because, it is, there's a lot of conflict between siblings and who thought they were going to do what, and like, well, they've been living with me, I should get this. And even if people who are powers of attorney, they are, I guess having the documents doesn't mean there's not going to be, like, bad things aren't going to happen. And so you really need to choose wisely. And like, even if they have documents, like, go back and say, hey, is this still what you want? Because, it's and then with second marriages or third marriages and, step kids, like, it just gets complicated. And so in situations like if it is a second marriage, like giving the kids, the biological kids, something when that parent dies, and not just giving everything to the spouse. I mean, there's situations where it's the second marriage is 25 years and like they've thrown everything together, and it's the surviving spouse is kind of depending on, that money to move forward. Those adult kids need to know what the plan is, so they don't, and just because once you destroy a family dynamic through like these documents or through beneficiary designations, and you've passed and you can't come back to fix it, like, I unfortunately hear like so many times like, oh, well, my mom and my aunt haven't spoken to each other since my grandma died, or the evil stepmother took all of our money. That happens so many times. And even it doesn't matter the amount, like it could be $100,000, could be $10,000, it could be 10 million, and people are like still angry if someone gets more money than they thought they should. And another great document to utilize is a memorandum of distribution of personal property. So you can list, like people fight over things as well as money. So like it's grandma's sugar bowl or grandpa's watch, or, like heirloom pieces that please keep this in the family, or, this should go to so-and-so. And then, so that again, it's the clearer it can be, the easier it is for the family. And so, and I try not to litigate because I'm a lover, not a fighter. But I like to, you have to be sort of prepared for, people, when people die and there's money or things involved, there's a crazy, people get, pretty gripped. And so sort of like, and then you can use it to punish people too. Like you could give someone your china and make them take it, because nobody wants china anymore. But that's, I have to keep myself entertained. So my poor kids, like, they hear me talking about dying. We have conversations about it. So like every once in a while, my daughter, and it's a really great wooden spoon. And we make these monster cookies that it's 3 pounds of peanut butter, 18 eggs, or a dozen eggs, 18 cups of oatmeal. And it's like this paddle, and you have to like almost stir it with your whole hand. And one of my daughters is like, put this on my list. I want this wooden spoon. And then my other daughter's like, no, I want the wooden spoon. And my son doesn't really bake, independently at 20 right now, who knows, but I may have to find 3 of these wooden paddle spoons so that nobody gets angry when I die. But we talk about things, and like even my mom, my brother and I were home, and she's like, well, David, I think you should have this. And I'm like, no, that's for me. He doesn't want that. No. Put my name on the back of that mirror. I like that mirror. And we did it in such a way that it was hysterical actually. But if you don't take death so seriously, like it doesn't have to be so horrible. Like it's going to happen. So like keeping it as light as possible and having the conversations and asking people what they want, or if you're going to, if there's a child who's number 6 at Google and then another child who's teaching kindergarten in Flint, Michigan, like there's going to be disparity of wealth. And so maybe your assets go differently. And as long as you say, I love you the same, and you can say lovely things. You can say thank you. You can show gratitude in the document, and you can write letters to everyone. So everyone knows what to expect. then I think, it doesn't have to be even Steven, but you just have to tell them why it's not even Steven. And so, just like being thoughtful and keeping up to date, keeping your list of assets up to date so people know where to find them. It's just, it's important. So
Stephanie, there are a couple of questions in the chat. I don't know if you can see the
oh,
chat.
okay, hang on, let me.
So somebody had to leave early, but I just asking about more, if you can say more about the memo of understanding. Is it always honored by the courts? And then additional person, can you speak about the legality of wills and et cetera that were drafted without an attorney?
Okay, so the memorandum of understanding, it's mentioned in wills, like as effective, like if, like, because you can also give specific gifts in wills. So like if there's things that are super valuable or you'd want to give a cash gift, you have to put cash in the will as a specific gift. And then the next paragraph talks about the memorandum. So it is incorporated. And so it should be honored always as part of the dispositive document.
Mm-hmm.
Can you speak about the legality of wills?
Written with, I think that was written without an attorney.
Yeah.
Yeah.
In Colorado, you can handwrite a will. The best idea there is to have it self-proving. So you'd want it to have 2 witnesses and sign with the notary, even if it's not drafted with an attorney, just so that, like, that's part of what makes it, I guess, not like legal, but like verified that it's, like that someone else didn't just write it. And, I mean, again, I'm sure everyone's heard of like, oh, we're having handwriting analysis. Like, was this actually written by, by the person who died? And I mean, it does happen. And you can write them without attorneys. I would caution you around like the online stuff, because every state is different. And I've said this for the last 10 and 12 years, that my colleagues who do litigate will probably make more money trying to undo LegalZoom or Rocket Lawyer wills than they will writing their own, because they allow some conflicting paragraphs or sentiments. And then someone like I had to unwrap one early in my career where they created a trust and funded it with one asset, and there wasn't a will. And so then this one asset was in kind of this one document, and nothing else was addressed. So like making sure that like the document and the beneficiary designations, or if you create a trust, that you actually fund the trust. So like transfer the real property through a deed, through recording the deed, so that the trust owns it. Like there's still a lot of steps, making sure that the bank account is in the name of the trust. So there's, there's, if the purpose is to avoid a probate, and then you still have all these assets in your own name, when you have a trust, you still have a will. It's a pour over will that says, I meant to pour all my assets into the trust. And so you still go through the probate process, which is sometimes what people were trying to avoid. So there are, there's a lot of hoops in the creation and the continued funding, and like making sure everything, you buy a new house, that house should be potentially in your trust. And I had clients recently call and say, oh, we're selling our house because, we live in Longmont, and it's like someone was giving us an outrageous amount of money for it. But the title company said that it was in our trust. And did you do that? We didn't, we have no recollection of that. And I'm like, yeah, that's what we did. Like we signed deeds and I filed them so that, if something had happened, your trust would have owned it. And they're like, oh yeah, now we kind of remember. So like, even when you do it right, sometimes you forget, like, or you don't know like how it all works. And so it's really nice to have an attorney to talk to that can answer all different questions. And an online system can't. So that's and must certain documents be drafted by an attorney. Personal representative deeds have to be drafted by an attorney. So when you die and the estate is trying to sell the house, the way that property is transferred is through a personal representative deed, and an attorney has to do that. That's, I think, the biggest, or the one that's coming to mind that has to be drafted by an attorney. Like even probate, there's documents online, the court system has it so that you can fill them out without an attorney. I feel like, and it can be done, but sometimes it's the emotions of your brain. Like, and I know I can answer all the questions because I do it all the time. Like, so I feel like, oh, this is a pretty simple form. But if you haven't been reading the legal, language a lot, and it can be a little confusing. So that's, I think a lot of times people hire an attorney for the probate because it's just nice to be guided, because there's a lot of things that have to be done when someone dies. File a last tax return, shut everything down. Through the creating a death certificate, the funeral home does notify Social Security. And so then like all the other branches of government sort of start hearing about it. So those are just different pieces.
And that would be how Medicaid and Medicare would hear about it. Okay.
So are there any questions? I feel like I was talking fast and sort of rushed through the presentation. Let's see what else I had on my list. Yeah, I think like my goal is to sort of change the culture of dying, like one family at a time, by making people talk about a lot of different pieces of dying that they weren't expecting necessarily to get to when they came to me as like the lawyer. So that's sort of, if there's any questions, happy to answer some more, but otherwise we can conclude.
No, I'm sure I've got a question right here. So
okay.
Hey, Stephanie, I'm just wondering, this might be a loaded question, but I have quite a few clients who don't have, sorry, my Malamute's talking,
Yeah.
Hi, buddy, who don't have family, friends, anything for POAs. They don't have a will. They just pass, and there's no plan, nothing like that. Where does that go? I mean, like,
so each county has a special administrator who would take care of like the if there's any assets, and that's part of their job. The court appoints them to take care of it. So if there's nobody, there are, like, I think some end of life doulas are agreeing to be medical powers of attorney to help with that process. And then I don't like, I guess the special administrator would take care of, wrapping things up legally and financially. And I don't know sort of what else happens like in that situation, but I know that's kind of one, at least the county has those people in place.
That's helpful. Thank you so much.
Linda?
Yes, I wondered, is there an organization for death and dying doulas that's a good resource in terms of contacting and establishing that relationship?
Yeah. So there's several, like I'm working currently with 7 other doulas to create one in Boulder County called oh, this is really embarrassing. I think we're the Front Range End of Life Collective. And I can, like, if you would want to, I think you've got handouts of all my stuff. If you wanted to email me, I could get you more information that way. I don't have it like off the top of my head. We're still in progress, but we doulas are sort of springing up all over, and there is ANELDA is the new sort of national governing body of doulas, and so they have, like, you could look at their website and
what was
and
that?
then
I'm
they would
sorry.
have, like, listing of doulas in the area too.
Okay, and that was Inelda?
Yeah, ENELDA, I believe. No.
Okay, okay. And if your loved one or you are in hospice, is that still compatible to work with a doula with hospice?
Absolutely.
Okay.
Doulas don't do medical advice or legal advice generally. I don't do medical advice, but I can do some legal. But what they do is we work with a bunch of different sort of parameters. It's more spiritual and emotional, and some practical stuff where, do you have a will, or, do you want, a priest to come, or a rabbi, or, sort of spiritually, what do you need to have happen there? You can have hard conversations that maybe family wouldn't want to have. Like, there's a lot of people who, you hear, like, I didn't really know I was dying until it was sort of too late. And, like, they help sort of people get organized. So, like, if you have to say you're sorry to someone, or get in touch with a child who was, you haven't spoken to, like, they help people wrap things up. They also help families with grief, and they help with rituals. So, like, there's, like, visual, and, there's, prayers, and help with breath work as far as, like, pain management and just sort of support. So you can work with a doula, and most hospices enjoy the camaraderie and the collaboration, because
Okay,
we're trained not to step on their toes.
Okay, thank you.
Yep.
So again, we've got a question in the chat
Okay.
about estate planning packages.
Packages. Most of the attorneys I know and work with, or my colleagues, we do work sort of on a flat rate package, and it includes either a will or a trust. Like, I have 2 different packages, a trust package and a will package, and they include powers of attorney, medical and financial, the advanced medical directive, and the memorandum of distribution of personal property. If there's young children, I do a temporary guardian designation. And then another document, sorry, that I give people, but it's not, well, it's called the MOST form. It's the medical order for scope of treatment. It's a CPR directive, basically, and it needs to be signed by a doctor or a PA. But it sort of says, if I arrive not breathing and not with no pulse, do you do CPR, yes or no? And so that's supposed to be on file with your doctor. As well, I encourage clients to take their medical power of attorney document and their living will to their doctor, so that, again, creating that team so that everyone is on the same page, and having the hard conversation with your doctor about, like, they're trained to, keep you alive at all costs. And so if you can let them know that it's okay, there's going to be a point where you're going to be ready. I think that allows them to come to treatment with a better perspective. And, as a doula, I've been watching, tons of documentaries and stuff. And a lot of times it's the families that don't want the person to go because they don't want them to, give up, or fail and not lose their battle with cancer or whatever. And it's, it's a lot of pressure on a patient to stay alive when they're really in a lot of pain because their family wants them to. So like, if you have the conversation with the doula that this is, I'm getting ready, or your doctor, like they can support you in that decision. And I think that's where a doula can be great. Like, no, like, I know that you will miss your mom or your dad, but this is what they want. We've had these conversations, and I think it allows people to have hard conversations with a doula. And so that's part of the, those are different pieces of the package. And then, is there an estate planning certification? Not really. If someone is advertising or holding themselves out as an estate planning attorney, they're probably part of the estate planning bar, and we're super because we aren't adversarial generally, like we don't, like there's enough people that need our help. We aren't competitive, so it's not like a personal injury attorney where like there's only this $100 million case a year. Like, we really work well together. So if someone wants to do the work, they're committed to that kind of work. Like because estate planning attorneys don't make as much as like regular attorneys. So like we're a very special sort of breed or something where like we like to work together. We just like to help, and like somehow people, I mean, there's some, I'm sure, that make a lot of money when they're working with really, really high-end clients, but generally it's not like the money-making sort of situation. So if someone wants to do it, they probably love to do it, if that makes sense. And okay, wait, there was one more question here. Medical order for scope of treatments. Okay. An estimate for an estate planning package. My costs or my fees are, I do a will package for $1,200 and a trust package for $1,750. And I feel like I'm right about in line with most other people or most other attorneys in the area. There's some people that probably charge more. There may be a few that are less.
Is there any, Linda's got a question here. I will let Linda ask here.
Sorry, I thought I'd asked everything. I have a question regarding, my husband has Alzheimer's and is in the later stage of Alzheimer's. I have a question with regard to sorry, just a second, I was just sorry. Whether or not I'm assuming in 2013, he did a document about his final wishes and had it not notarized, but signed by 2 witnesses, and he signed it. And that was prior to his diagnosis. He later established a will with a medical living will, etc., and power of attorney and all of those things. But is there any value to that previous document if it includes things that were not included in the will? There aren't any really conflicts, but there are some specific things in the document that was signed but not notarized, signed and witnessed.
And he did a formal will with an attorney after that.
He did.
So generally, the will that an attorney is going to write is going to say, this will is I declare this to be my will and I revoke all other wills.
Okay.
If it's something where that will is giving like gifts that weren't given, like you could argue it could be a memorandum of distribution. Like if there's things that like, oh, he said his watch or his you know, something went somewhere else, like I would hold on to that sort of to include that as like just looking, it would just look at the specific gifts, but generally that one is revoked by the former or the early or the latest one.
Okay, I assumed that. I just wanted to be sure. Thank you.
Okay, I'm opening it up for last minute questions. And if we don't see any, we'll probably end in just a minute.
Okay.
Is there anything you might recommend, I guess, Stephanie, just for caregivers who, to make sure that they've got what they need for their care recipient? And what does that mean? I mean, just, I suppose, is there something you might make sure that they do just as they're doing the caregiving?
You know, I like, depending if there anyone is sensing like conflict, like, you know, potentially videotaping like conversations with the patient so that there's like proof of like this person actually said this, here's what they said, here's, you know, these were their wishes, so that you know, they have something to rely on other than just word of mouth or whatever. So that might be helpful if you're sensing, you know, family isn't getting along.
That's perfect. Thank you.
Okay.
Well, I think we're done. Lots of people are saying thank you. Good.
Yeah, that's so nice. Thank you guys all
Yeah.
for joining. And please, if there's questions, like shoot me an email. Like you know, this is a really important area to have good information on. And I love trying to help with, you know, keeping people in the know. So.
Right. Yes. We've all heard that. I think that comes through, and that we've all heard communication.
Yeah.
So thank you, Stephanie.
All right.
So glad to have you.
Thank you very much.
Thank you.
Okay.
Bye.
Nice to see you, Colleen.
You too, Stephanie.
Yeah.
Take care.
Okay. Bye.